My name is Beth DeVan. I'm a writing advisor in the John Marshall Law School Writing Resource Center. And today, we'll be discussing an overview of injunctions. As you know, plaintiffs in civil actions often ask for money damages to compensate them for their injuries. Money damages are one type of remedy. Courts also have the power to grant an equitable remedy, such as an injunction, also known as injunctive relief. An injunction may direct a party not to do something or to stop doing something, or it may order the party to start doing something. There are three forms of injunctive relief: temporary restraining orders, or TROs, preliminary injunctions, and permanent injunctions. Each of these remedies has its own rules and requirements of proof. Further, the rules governing injunctions vary between federal and state courts and between the different states. Federal Rule 65 governs injunctions in the federal courts. In Illinois, Section 5/11-101 of the Illinois Code of Civil Procedure provides the rules governing injunctions. Although the rules vary, the dominant inquiry is whether the party seeking an injunction will suffer an irreparable injury for which there is no adequate remedy at law, meaning money damages are not sufficient if injunctive relief is not granted. The primary purpose of TROs and preliminary injunctions is to maintain the status quo and to restrain wrongful acts while a case is pending in court. These temporary injunctions are just that, temporary. Conversely, permanent injunctions provide long-term relief. They stay in effect after the case has been decided on the merits. Temporary restraining orders are issued in exceptional and emergency circumstances. They are sought when necessary to preserve the status quo until the court can rule on a motion for preliminary injunction, which it does after hearing the parties' evidence. Generally, there are two types of TROs: status quo and mandatory. A status quo TRO requires the party against whom the order is entered to keep matters unchanged. For example, if Barbara wants to stop her neighbor Arthur from chopping down a stand of 100-year-old oak trees in the shared right-of-way in front of their homes, she could seek a status quo TRO, ordering Arthur not to remove the trees. Conversely, a mandatory TRO requires a party to take action that will change matters. For example, if an oak tree on Arthur's lot line has grown so large that it is lying on the roof of Barbara's garage, she could seek a TRO ordering Arthur to chop down the tree. A party seeking an injunction must file a written motion to bring the matter before the court. Injunctive relief is generally sought after a complaint has been filed, but the motion for an injunction and the complaint may be filed simultaneously. The complaint contains the factual basis for a determination that irreparable injury is imminent and that injunctive relief is warranted. The standard for pleading is more rigorous than a standard complaint. The plaintiff needs to set forth material allegations based on specific facts, not hearsay, speculation, or based on information and belief. In most instances, the party seeking the TRO must give notice to the other parties. However, in an extreme emergency, a party may seek a TRO ex parte without giving notice to the other party or parties. The movant must argue that the threatened injury is so imminent that there is no time to provide the other party with notice of the motion. The court will not hear evidence, but will review the filings, the motion, and either a verified complaint and/or affidavits in support of the TRO. If the court is satisfied that an emergency exists, it will enter a TRO. Unless the parties agree on how long the TRO will stay in effect, it will expire automatically. After 14 days in a federal court case, 10 days in an Illinois action. A limited extension of the TRO can be granted. Thereafter, the party seeking to keep the TRO in effect must move for a preliminary injunction. Finally, both Illinois and federal law provide that a TRO is binding upon all of the parties in the case, as well as their officers, agents, employees, and attorneys, and upon those persons in active concert or participating with them who receive actual notice of the TRO. To secure a preliminary injunction, there must first be a complaint on file. The party seeking a preliminary injunction must provide notice to all parties. The motion should include evidentiary support, such as affidavits, verified pleadings, and depositions. The party against whom the injunction is sought will have the opportunity to respond to the motion. The movant must establish the following legal elements in order to obtain a preliminary injunction. The movant has a reasonable likelihood of success on the merits of her case. The movant has no adequate remedy at law for her injury. The movant will suffer irreparable harm unless the injunction is granted. The threat of harm to the movant, if the injunction is not granted, outweighs any harm to the other party if the injunction is granted. The public interest would not be disserved if the court enters the injunction. The court will review the pleadings, motion, and evidentiary materials. In some instances, the court will conduct an evidentiary hearing. The court renders its decision and enters a preliminary injunction or denies the motion. The preliminary injunction will remain in effect until it is dissolved, vacated, or made permanent after a trial on the merits is completed. Preliminary injunctions usually do not last for more than 1 year. The cases often settle, or the injunction becomes permanent after trial on the merits. This leads us to the last type of injunction, permanent injunctions. On the motion of any party, the court may enter a permanent injunction after a trial on the merits, where the rights of the parties have been fully litigated. The elements are generally the same as a preliminary injunction, with the exception being the first element. Instead of there being a likelihood of success on the merits, the party has already succeeded on the merits of its case. A permanent injunction survives, or stays in effect, beyond the end of the lawsuit, subject to later amendment by action of the parties and decree of the court. Any court action on an injunction is what's referred to as extraordinary relief, which means that the disappointed party can seek an immediate appeal. This applies if the court grants the injunction, denies the injunction, modifies the injunction, or dissolves the injunction. Injunctions are among the most powerful remedies available to litigants because they can compel or restrain a broad scope of actions. Given this power, courts do not grant injunctive relief as a matter of course, but do so only when a court determines, in its discretion, that fairness and equity demand a party be enjoined. And because TROs and preliminary injunctions are granted before a case is tried, they are even more extraordinary measures. A court will allow them only when stringent standards are met. Finally, because a party could suffer serious harm if it is wrongfully restrained or enjoined under a TRO or a preliminary injunction, Federal Rule 65C requires that the movant post a bond before a TRO or preliminary injunction will be issued. Posting a bond means the movant has to give the court a sum of money that will be held by the court until resolution of the matter. The Illinois Code of Civil Procedure has a similar bond requirement, but it is imposed only at the court's discretion. If a court later determines that the defendant was wrongfully enjoined or restrained, the defendant may recover costs and damages through the bond. This has been a brief overview of injunctions. To get more information, go to the federal rule or the Illinois statute on injunctions. You can also find information on injunctions in Illinois through ICLE, I-I-C-L-E, which can be found on the 6th floor in the library or on the library's web pages.